Now, staying on the NPA, the DA Member of Parliament on the Committee for Justice and Constitutional Development, Damien Klooper, says the National Prosecuting Authority is failing at the most basic level, with the Timothy Omotoso case being the latest example. The DA held a media briefing this morning to highlight what it calls the NPA's continued failures in handling priority crimes and cases linked to state capture. Joining us for more on the NPA is Accountability Now's Advocate Paul Hoffman. Good afternoon, Advocate. Thank you very much for joining us on Point. So the DA has joined many in reacting to the prosecutorial challenges of the NPA, if we can call them that, when it relates to high-profile cases. Now, many are not only citing the latest Mradi-Cholota extradition, but the Guptas, the Omotoso case, quite a number of them. Now, the DA says the best option now could be an anti-corruption commission that accounts to Parliament directly. Your views on all of this?
Yes, thank you for the opportunity, and good afternoon to you and your listeners, your viewers. The NPA gets blamed for a lot of what is wrong about the criminal justice administration in South Africa, and quite often unfairly so. The NPA has been likened to a Volkswagen Beetle that is being entered by our government in a Formula One race against McLarens and Ferraris and Mercedes-Benzes. And if you put a Volkswagen Beetle with its small engine and its limited capacity in against these thoroughbred racing machines, then you must expect it to lose. And that is, in fact, what has been happening. And it's not the fault of the National Prosecuting Authority that they have no success, or very limited success. I heard in the insert at the beginning that the National Director of Public Prosecutions seems to suggest that there is not so much wrong with the cases that have gone awry. The truth is that, unfortunately, the capacity of the criminal justice administration in South Africa, from the detection and investigation and prosecution of corruption, has been hollowed out completely due to the state capture that took place within the National Prosecuting Authority itself during the last decade or more. That process of state capture is ongoing.
Now, Advocate, if I may interject just there, to just get clarity on this aspect. If you've got the NDPP stating that essentially many people need to get greater context as to why they failed with their prosecutions on those specific matters. But some of these matters, in as much as you speak of the hollowing out of some of these institutions, which many don't deny, but if you're failing at very elementary aspects of a case, which is a simple case in point is the Mradi-Cholota. In that matter, you had Judge Loubser speaking of just a very elementary aspect, which is that the NPA cannot request an extradition. We've got an SCA judgment that has stated that. So it is currently standing law. If you want to challenge the SCA, by all means, you could have the NPA going to challenge it. But as it stands now, that is what you must interpret, that what must happen is that it must be the minister who requests an extradition, not the NPA. So, I mean, these are very elementary, one would assume, which doesn't really speak to the hollowing out or the need for greater skill sets within the NPA. It's just basics, as the Democratic Alliance has said. At times, the failures are basics.
Yes, and that is because the skill set within the NPA is not up to standard. That is the nature of the problem, that the people who are prepared to work for the low salaries in overtaxed institutions are not of the quality that one would expect in a highly functional NPA. And that problem is going to continue while the NPA is left with the task of anti-corruption work, which isn't actually its job at all. The anti-corruption work ought to be done by an institution such as that is now being punted by the DA, the Anti-Corruption Chapter 9 Commission that is envisaged in the bills that are currently pending before Parliament. That court order was made in 2011. So while it's true that recently the SCA has changed the dispensation in relation to who has the task of looking into the question of asking for extradition. No, that's a recent change. The court rulings in the Glenister litigation, which were made in 2011 and then again in 2014, make it very clear that the courts require, in terms that bind government, that there be a separate single institution outside of executive control that is tasked with corruption work. Now, Charlotta is a corruption case. She's charged along with Ace Magashula and others in relation to the asbestos roofing scandal in the Free State. That case ought to have been prosecuted and investigated by a body outside of executive control that could have done the job, couldn't have done it worse, but certainly could have done the job somewhat better than has been the case with the NPA and the Hawks, who were the system that the courts were criticizing way back all those years ago. So it's taken time for the DA to get to the point where it says we accept that there ought to be a separate body outside of executive control, and they are suggesting that a Chapter 9 institution be created for this purpose. Now, that isn't happening in any great speed. It's the government itself, the executive branch of government, has appointed a National Anti-Corruption Advisory Council to roll out the National Anti-Corruption Strategy, which does not take proper account of the binding nature of the rulings in the Glenister litigation. And until that is done, we are going to continue to struggle to get to grips with serious corruption and organized crime in South Africa, which is why the DA has come round to the realization that fundamental reform of the criminal justice administration, in order to bring it into line with the 5 main criteria of the Constitutional Court in Glenister, which are specialists who are trained in anti-corruption work and only do anti-corruption work, who are in an independent institution, that means structurally and operationally independent of the executive branch of government, who are resourced in a guaranteed fashion and who are secure in tenure of office. You don't lose your job like the Scorpions lost their job because they did not have institutional security of tenure of office.
Fair enough. Fair enough. When you speak of security of tenure, that has been the most contentious one. But when we look at the investigating directorate, is this not essentially what it was for? Because there was an element or a time when the ID had those problems, that it lacked that security of tenure. They couldn't then attract the necessary skills because many people wanted to know that they have a job beyond 6 months or a specific case that they would have resolved. So we had the ID now being capacitated, but beyond this, there's then another body that must be created, or at least this is what the DA wants, beyond ID. Why are we not trying to further capacitate ID, that now at least we've dealt with the security of tenure? Perhaps now you need a different funding model, because there's also the element of competitive salaries, that you're not going to take highly skilled people from the private sector and bring them to the investigating directorate and then they're not being paid well. So is it not better for us to focus on the ID and further capacitate it?
No, it's not, because the ID is no different to what the Scorpions were. It is a creature of an ordinary statute, and it can be closed down by way of a simple majority vote in Parliament. That's what happened to the Scorpions. When Jacob Zuma became president, he did not want to have functioning anti-corruption machinery. The Scorpions was working far too well as the body getting up the noses of too many highly politicized and well-connected people in the realms of grand corruption in South Africa. It was actually the incipient part of the state capture process. So the Scorpions were closed down by a simple majority, and the same thing can happen to the ID, because the ID is no different to what the Scorpions were. However, in order to close down the Chapter 9 institution that the DA now has in mind, the Anti-Corruption Commission, you would have to muster a 2/3 majority in Parliament, which in the Parliament as it is today and appears to be in the future, a 2/3 majority is quite difficult to secure. So IDAC, I'm afraid, is not the answer to the problem at all, because IDAC is no different to what the Scorpions were, and we all know that the Scorpions were summarily closed down when Jacob Zuma came to power.
All right. Advocate, thank you very much for your time. Unfortunately, we have run out of time, but always a pleasure speaking to you and sharing your insights with us. That's Accountability Now's Advocate Paul Hoffman speaking to us there.